Okay, good evening. We're going to get started. Welcome to the Newmarket Zoning Board of Adjustment meeting for Monday, August 6, 2012. And the first order of business is the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The next order of business is the review and approval of minutes of the July 9th, 2012 meeting. Have we had a chance to review?
I have not.
I have not either.
Okay, then why don't we defer that issue to the next meeting? And the third order of business is the regular business for the evening. This is an appeal from an administrative decision by Walter W. Cheney. The applicant requests an appeal from administrative decision to allow for the issuance of a building permit, the application for which was denied due to the lot being determined as, quote, unbuildable open space, unquote. The lot is located off Cushing Road, tax map R2, lot 36-13, zone R1. This application was originally heard on May 18, 2009, and a motion was made and unanimously passed to postpone any discussion on this issue until the lawsuits that were pending at that time have been properly adjudicated and the board has legal answers in front of them by which the board can then render a decision. The applicant has requested a continuance of this meeting to be held, stated that resolution came on March 3rd, 2011, when the Rockingham County Superior Court ruled in his favor that Lot 13 was owned by Walter W. Cheney and that Lot 13 is an independent lot of record. And so the way I understand it is we're here tonight as a continuation of the May 18th, 2009 meeting. At that point, there were basically two issues on the table, one of which was whether or not the consideration of the denial of the building permit would be deferred, which is what happened. And the other significant issue, according to the meeting minutes, was the issue of whether or not the ZBA had jurisdiction over this appeal under the applicable ordinances. So what I'd like to do in terms of the way we proceed tonight is first ask the applicant to address the question of jurisdiction specifically, and everyone who wants to speak, please, in this initial round, limit yourself to the question of our jurisdiction here this evening. And then if we get past that issue, we'll have further presentations on the merits of the matter if we get that far. I've looked through the file. I see that we have certified mail receipts from all the abutters, according to the abutters list that was provided to us by Mr. Cheney. And so, Mr. Cheney, if you'll step forward and please address the issue of our jurisdiction first, based on the information from Laura Spector's letter back in May of 2009, we'd really appreciate that.
You're asking me whether you have jurisdiction?
Yes, sir. I'm giving you an opportunity to tell us specifically what part of which zoning ordinance is at issue here tonight. I see a lot of discussion from all the old materials, from materials we've received from the town's attorney, and from the materials you presented tonight about the subdivision regulations. And I'm wondering whether there's any provision of the zoning ordinance that's at play in this application.
I have no reason to believe that the ZBA cannot hear this case. Whenever there's been a building issue, that I've been doing this for 51 years, you've always gone to the ZBA if you have an issue with the building permit. So I have no personal issue, and I haven't done any personal research or effort in determining that. I thought that was a town issue, not an issue I raised. I'm happy to be heard and have an opportunity to present my case, and that's the most I can contribute.
Okay. Is it fair to say that there's no provision of the zoning ordinance that's at play in your application? I didn't see anything, and I'm just wondering. So I'm correct.
That there's nothing in my application relevant to what?
to any provision of the zoning ordinance, as opposed to the subdivision regulations? Okay. All right, what I'd like to do for the time being, because this is a very important question, we can only hear what we're authorized to hear, and as you know, the ZBA has very limited statutory authority. What I'd like to do for the time being is hear from the town's attorney,
Okay.
and then hear from anybody else who wants to contribute something on this topic. Mr. Richardson.
Thank you, Mr. Chairman. Justin Richardson, as many of you know, I'm town council. I serve with the firm of Upton and Hatfield, and I'm here to present this matter on behalf of the town's planning department. I understand the legal issue that's before the board, and when you look at RSA 674-33, it talks about whenever an administrative official makes a determination relative to the zoning ordinance, this board can hear an appeal. I would caution the board, I think, not to go to, to put all of its eggs in one basket, as it were, and simply rule that it doesn't have authority. I think that's really a legal question, and that ultimately should be decided by a court of law. And the reason is that if Mr. Cheney isn't entitled to bring his appeal from the denial of his building permit, I don't think that there's any direct local avenue that he would have to appear before a town board, other than to replead his case to the same official who denied his appeal. And I went and researched the issue since then, and there's a couple things that came to my mind. One is when you look at the very nature of a subdivision regulation, and I believe it's RSA 674-35 I'll draw your attention to. And I'd be happy to follow up with a memo on this so that you could share this with your council if you wanted advice on it. It says, a municipality may, by ordinance or resolution, authorize the planning board to require preliminary review of subdivisions and to approve or disapprove in its discretion plats, and it goes on to basically talk about subdivision plans. And the key word is there by ordinance. And effectively what the town is doing when a town votes to authorize a planning board to regulate subdivisions is giving it essentially a form of zoning power, and you're doing that by ordinance. Now, it doesn't say zoning ordinance, and understand this act is different than what the planning board would do, which wouldn't be the municipality, but would be the board adopting regulations. And that's under a different provision in the statutes, whereas this is the actual town saying, planning board, we're going to authorize you by ordinance. In other words, we'll enact an ordinance to say that the planning board now has the power to adopt regulations and to regulate subdivisions. And then the planning board comes up with regulations that gives the building officials the authority to approve or deny applications. So that's one provision that I draw your attention to. Another one is a bit of an odd duck in that it doesn't appear to directly address the issue, but if you turn to RSA 676:5, and I see you have the same book in front of you, and I'm looking at page 557.
I think I've tabbed the same pages.
Okay, all right. And it says, talking about this is entitled Appeals to the Board of Adjustment. In 676:5, Roman numeral 3, it says that if in the exercise of subdivision or site plan review, the planning board makes a decision or determination which is based on the terms of the zoning ordinance or any construction, interpretation, or application of the ordinance, and then it says which would be appealable to the Board of Adjustment if it had been made by an administrative officer. So what's very unusual about that to me is that if you were to read the 674-33 provision to say it has to be a zoning ordinance determination, that's the only thing that can be appealed to this board, this provision wouldn't make any sense because there would be no administrative decision under the subdivision or site plan regs that could be appealed. You know, there'd be no appeal from the planning board and there'd be no appeal from the administrative official. And so I think what has to be recognized is that these statutes kind of go back to a simpler day when everything was kind of put into the same pot. It was zoning, whether it was subdivision review, or whether it was site plan review, or whether it was denial of a permit clearly based on a specific provision of the zoning ordinance. And the statutes were written to allow that review to occur locally. So that's my view, and I think that there are cases that support that. And I'm not going to ask you to read them, and I'm not going to read from them generally, but I'll give you the citations. And like I said, I could follow up to address this issue more specifically. But in the case of, McNamara v. Hirsch, and it's 157 New Hampshire 72, and it's a 2008 decision. And the court specifically says that ordinarily, challenges to decisions regarding building permits must first be made to the Zoning Board of Adjustment. And there's a decision that is, like this one, it's an appeal of a building permit. The other provision that I draw your attention to, and there's some confusion in this case, it's complicated, but it's Ouellette v. Kingston, 157 New Hampshire 604, also in 2008. And it talks about a zoning board's authority to hear appeals that relate to a historic district ordinance and regulations. And that is something that doesn't, at least as far as the regulations adopted by an HDC, that's not, strictly speaking, a zoning ordinance. That's a regulation adopted by that board about use of historic properties and how they review it. And the Supreme Court upheld a zoning board's decision to hear a case, and actually the zoning board in that case reversed the decision by the HDC under its own regulations. So I think that, in light of, I think it's a complicated issue, and I would caution this board not to put all of its eggs in one basket, given those complexities. I think it would be better if this case were heard and decided by the ZBA in the first instance, and if you're inclined to believe that you may or may not have the authority, I would kind of rule in the alternative to say that, well, we've heard these arguments, we've given our ruling on the merits, we note that there is a legal question before the board that should ultimately be decided by the courts in the event that either party appealed. That would, I think, allow the case to, if a court were to find that there was jurisdiction, it wouldn't have to get sent all the way back a year from now to be done over again. And if the court found that there was no jurisdiction, then we'd still have the benefits of the ruling, and it would essentially, we'd be in the same position. So I apologize for the length of that answer, but that's kind of where I stand on this issue. There's a legal issue out there. I think the better ruling is that ZBAs are meant to hear local matters. This is clearly a local matter. It's clearly a case involving a building permit, which the Supreme Court has said this board has the authority to hear.
Thank you. Any member of the public care to address the issue of jurisdiction that we've raised here this evening? If we move on to the merits, you'll have a chance to speak again, but right now we're just focusing on the issue of jurisdiction. I see her. Anyone aside from the town planner? Okay, Diane.
With all due respect to our legal counsel, I do understand there's a difference of opinion between him, and Laura Spector, who is the former legal counsel for the town regarding this matter. And I just wanted to point out in her letter of May 18th, 2009, that she feels that the board lacks jurisdiction
And the reason for that is that this application concerns a subdivision that was approved by the Newmarket Planning Board November 12, 1985. And it was clear from the record of that planning board at the time what the intent was, and that there is another avenue that Mr. Cheney can pursue, and that is to make modifications to his approved site plan, send it back to the planning board, and ask the planning board to reconsider given changes in circumstance, changes in market, changes in information that's now available, and ask for the planning board to consider a revision to the plan. And perhaps that revision would include carving out a lot for a single-family home on Lot 13. So I would just like to reiterate what Ms. Spector stated, that the determination of whether Lot 13 is unbuildable is not based on an interpretation of the zoning ordinance, and since the zoning board does not have authority to interpret subdivision regulations, that there is no jurisdiction to hear the appeal of the denial. And for that reason, the zoning board should dismiss the appeal. Thank you, Mr. Chairman.
Thank you. Mr. Cheney, happy to give you an opportunity to say anything further before we take up. If you want to step up to the microphone, please, so everyone at home can get the benefit of what you're saying.
I've been dealing with the town a long time, and no one has ever heard my side of the story. We've heard everybody's side of the story but mine. And this happened 27 years ago, and everybody thinks they know what went on there, but at least probably in this room, I'm the only guy that was there. And I'd like to be heard somewhere along the line. If I have to go to court, I can go to court. But somebody's going to hear my story, and it'd be nice if my story could be heard. And when you put the facts on the table, it has a whole different flavor than what everybody's heard to date. You know, and so I'm asking to be heard. I don't know the legalities of it, but certainly the town attorney feels I should be heard, and I'd like to be heard.
Okay. We have, just so, and I hope it was clear before, we have all reviewed all the materials you submitted back in 2009, and the materials we've at least looked at, the materials that you submitted here tonight. I know I've read through them. So to the extent that reading this reasonable stack of paper is being heard, I hope you don't feel like you're being shortchanged in that respect. We have read all the materials that you've submitted. But the question of jurisdiction is really serious. The ZBA has very limited authority. The authority is set down by the statutes. We don't have any authority to modify or change what is within our power to do. Typically what we do is hear appeals from decisions of administrative officers, like the code enforcement officer, that relates to an interpretation of the zoning ordinance. Like if a building permit is denied because the building, if constructed, would violate a setback or something of that nature that's under the zoning ordinance. And we hear requests for variances and special exceptions that are provided in the statute. The way I read the statute, RSA 676.5, it says that appeals to the ZBA concerning any matter, this is subparagraph 1, concerning any matter within the board's powers as set forth in RSA 674.33. And when you turn over to that statute under subparagraph 1A talks about hearing and deciding appeals from decisions of an administrative official in the enforcement of any zoning ordinance. So we don't, at least the way I read it, I don't believe we have any power to hear this appeal, because there is no provision of the zoning ordinance that is implicated. The remedy may be in Superior Court. I don't know exactly where the remedy lies, and then our ruling on, or our decision on what our powers are under the statute is not binding on the court. The court's going to make its own interpretation and decision. This thing appears strongly to be heading back to court one way or the other. I'm a little bit confused, I have to say. Based on the decisions of the court and the underlying case, I thought the court made a finding based on Mr. Cheney's testimony that the intention was for this lot to remain as undeveloped. You're saying no. Okay. But anyway, we're not even, that question isn't even that significant. The court's going to make a decision on all that. So the way I read these statutes, we don't have the power to hear this appeal. And I guess what I'm proposing to do is entertain a motion to dismiss the appeal for a lack of jurisdiction.
I'll make a motion that we dismiss this appeal based on lack of jurisdiction.
Do I have a second?
I'll second it.
May I speak to one issue before the board?
Sure.
On the motion?
And I apologize, I probably should have closed the public hearing.
No, that's
Go
all
ahead.
right. Well, and I was anticipating, based on your discussion of the issues, where the board was going. And what I wanted to do in light of that is obviously not re-arguing the legal positions. I think ultimately, you know, it is, like you said, it's an issue that the court's going to decide. What I did want to do is give you one additional document that I think sheds some light on the record in response to what Mr. Cheney's presented, and that has to do with, you know, whether or not, or what the intent of the planning board was. And I noticed in reviewing and preparing that the date of the final approval, that was November 12th, 1985, there's minutes for that meeting. And I thought it would be helpful to just submit those to the board so you can add them to the record, and then wherever this goes, if it gets appealed, it'll be part of the record. So I'd just like to make an offer to present that to you.
Let me just take a look at it, please.
Certainly.
Do you have a copy for Mr. Cheney?
I do. I'll deliver one to him now, and I have 10 copies, so I'll cut it up for anyone that's here. Well, almost.
It may be something that we already have, because we have meeting minutes in the file already, but let's just double check.
What date is it? What date was it?
Yes.
November 12th, 85?
And I'd be happy, I'll make sure that Diane has these, and anyone can ask tomorrow at the town hall.
I'm taking a file, putting it in the
Okay.
town's file
Okay.
right now.
Excellent, thank you. Simply put, what I wanted to draw to the board's attention is that on the third page of this document, you can see the actual motion to approve the Moody Point plan by the planning board. This was in 1985, and you'll see that it's included 3 letters from Attorney Malcolm McNeil that were imposed as conditions with all the other requirements previously discussed.
What page are you referring to?
Okay, I am on the first page is here. If you flip it over, you see the second page on the back side, and then the third page. We're looking at, it's entitled Agenda Item 2, and this is the planning board's final motion deciding to approve the 1985 plan, which I believe is number 14312, which is Exhibit
Okay.
5 or 7 in the
I
record.
see it, yes, thank you.
Yeah. So that, I just wanted that to be part of the record, so that if and when this gets presented to the court, we've got that before the board.
Okay. Well, it doesn't appear to relate to the jurisdictional issue, but you've submitted it, I've stuck it in the file for what it's worth. Any further comment on the issue of jurisdiction? Yes, sir.
It's amazing this can happen, but I was there, okay? We've all seen these approvals, okay? When they talk about all other requirements previously discussed, okay? Now, logical people would think that would mean anything that was discussed and voted upon. If you've ever attended a planning meeting, there's everything discussed, everything under the sun. In this particular case, we've gone through 2 entirely different plans. All the studies were done on one plan, and then there was another plan done. People get up and talk. They talk about Lot 13. Lot 13, when it was approved and studies were done, looked entirely different. If you would give me 15 minutes here, I could I can show you that everything that anybody has ever said is false. They don't understand what they're talking about. And it's very frustrating there's no one this gentleman here is the only gentleman in the entire town that has communicated with me and talked to me. He's the only person. That's a disgrace. I went to the town council. I've asked anyone to meet with me and look at the facts. Walk through the ordinance step by step by step. If you people would take my book home, assuming you're going to send me home tonight, if you take my book home and just take everything that you've heard today and look at it and compare it with the facts, that when people talk about Lot 13, Lot 13 isn't Lot 10. But they want to call Lot 10 Lot 13, and it's very, very frustrating to have to be put through this.
Anything further? Seeing no one, I guess we'll close the public hearing and we'll go back to the motion, which was a little premature, but is still on the table. So we've got a motion and a second. Okay, all those in favor, please signify by saying aye.
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 This point, do you need my vote? Do you count
Are you
as 3 to
abstaining?
4? I'd like to, just a quick discussion if we have time, because I just have a single question to address, and then
Okay,
we can move forward with the vote. Is that all right?
go ahead.
So as the town attorney brought up, is there harm in our determination that we don't have jurisdiction, rather than hearing the case, making a decision, and noting that jurisdiction was in question? And maybe you can just help me come to understanding on that
I think,
concept, because that's a new concept that I hadn't considered before.
what I'm concerned about is that we end up wasting a lot of time and a lot of energy hearing something that I'm convinced, based on the way I read the statute, and a judge may certainly disagree, that we just don't have the authority to do. And so whatever we have to say about it ends up being kind of pointless, meaningless, and it ends up being a waste of time. I understand this issue's been out there and was capable of being an issue jurisdiction, was out there and capable of being addressed at the time, and for whatever reason it wasn't. I just think this issue is heading to court one way or the other. And so let it be done, let it be heard fully by people who have the authority, someone who has the authority to give the relief or make a determination that's going to be binding on everybody, rather than us spinning our wheels doing something that's, in my view, got a very strong likelihood of being a waste of time. So that's kind of the way I view it.
Okay.
Let me just make one quick comment. I mean, I'm all for hearing anybody and giving people the opportunity to have their say, and that's the right thing that should be done. But my looking into it, I don't believe we have jurisdiction, and therefore, what's the point in doing a full hearing on it?
If there was some section of the zoning ordinance that we could point to and say, this is where
That's
the
what we have
building
authority
inspector
for.
heard, then, yeah, we clearly have jurisdiction, but I don't think it's,
Yeah, in a different context, you often hear the term judicial activism, which is people thinking that judges make decisions that they have no real authority to make, and that's a species of kind of what the concern is here. Our jurisdiction, our power is very limited by what the words of the statute say.
Okay.
So,
I mean, I didn't see it going through the zoning ordinance where what we have authority over. So that's why I've come to the conclusion we don't have jurisdiction, albeit the town attorney says we should still hear it.
I do agree. I just wanted to entertain that conversation quickly, since it was a new concept to me prior to voting. Thank you very much for delaying.
no problem.
Continue.
Are we set?
I'm set.
Okay, so all those in favor, please signify by saying aye.
Aye.
And I'm an aye as well. And all those opposed? Motion carries. Any other business to come before the ZBA this evening?
Talk about time. Okay? It's a disgrace that this board could not have made that decision before they wasted all of Justin's time and all my time, okay? He's put many, many hours to prepare a case to defend here tonight. I happen to gave up my whole weekend because I didn't get notified, probably my fault, but I did not get notified. And this, you didn't need us to make that decision. It would have been common courtesy for the town of Newmarket to make that decision in advance before spending all of his money and all of my time. I don't think that's very fair to anybody.
Respectfully, Mr. Cheney, we're the ZBA. We're a sort of a quasi-judicial board, right? We can't write letters. We can't do stuff other than in public hearings and public meetings. We really had no choice but to go through this process, to pay attention to everything that was submitted, and make a determination. We don't have the authority to call you up and have discussions about things. It's just not within our power, and I think you know that.
Okay, if that's true, I apologize.
Yeah,
But wouldn't somebody within the town have the authority to do that?
I don't believe so. I mean, the application is before us, and nobody in the town administration, nobody in the planning office, nobody has the power to make these decisions but us. It's given to us by law. So I appreciate the fact that, that time was, I don't think this time has been wasted, because I think you're going to take this material, and Mr. Richardson is going to take his material, and it's going to end up before a judge in the Superior Court, just with a different caption on it. But I appreciate what you're saying. It's just not within my power to write you letters, and I have to do it in public, and so everybody can see what I'm doing.
Apologize.
That's fine. No, I appreciate your frustration.
We can't even discuss anything like this, except in a forum
We
like
can't
this.
discuss it among ourselves, and we have to do everything in public, and this is part of the, delay is part of the process.
Fortunately.
So, you're frustrated because no one will talk to you. No, maybe there's nobody who can talk to you about it. I don't know the answer to that, but I know we can't.
Now that we've discharged the decision, we can talk to you about it, because there's no... I'm sorry.
Is there any other business to come before us this evening?
Mr. Chairman, I'd just like to note that, I did discuss with Walt that, I didn't know where you were going to rule, but I did kind of say it was out there, and, I also told him what my position was going to be, and that I was going to ask for the board to rule on it. So it's,
Yeah.
it is, it's part of the nature of the beast, as the chairman, I think, described, is that, he's got to focus on the meetings, and sometimes it happens that way. But we can continue to talk about, a way to get this resolved as, inexpensively and efficiently as possible, and we'll endeavor to do that.
I'm all in favor of people reaching reasonable accommodation if it's possible, and if it's not possible, that's what courts are for. But I don't have anything to say about it. Yes, sir.
Yeah, I just had a question on ZBA authority, because that's all the things that
Yes, sir.
we heard tonight.
If you can just identify
Okay.
yourself.
Yeah.
No, you can come to the microphone and
That's
identify
fine.
yourself. 'Cause
My
someone's
name
going to have
is-
to type this up at some point.
My name is Russ Simon from Cushing Road in Moody Point. When you're speaking about authority, I didn't know if you knew whether the ZBA had authority or any other area in town for providing the community with the drainage plans and the water and sewer plans that have never been surfaced by the developer or anybody else in Newmarket. Does the ZBA have the responsibility to surface those plans? Because for 9 years, we've asked the town and everyone else for copies of plans so we can manage our property, and the developer, the lawyers, the town, DES, no one seems to have those plans. So I didn't know if the ZBA had the authority to get those plans surfaced.
I will say this, the ZBA has no secret stash of documents, to my knowledge, other than what's bouncing around in the back of my car, which is a copy of what's already in the file. If if you make requests through the town, either the town has them or
Oh,
they
we've
don't.
made requests by great news, but I was just asking only because it was a jurisdictional issue. Thank you for hearing me.
Sometimes things are exactly as they appear to be. Any other business?
I don't have any motion to,
I'll entertain a motion to adjourn.
I'll make that motion.
Second.
All those in favor?
Aye.
All those opposed?
Thank you.